Hello students. Be ready for the dictation. Start. 8. Repelling the contentions of the appellant, the learned additional Solicitor General appearing for the respondents submitted that due procedure has been followed and ample opportunities were provided. The translated version of the grounds of detention along with the relevant documents were attempted to be served upon the detainee on the very next day after his detention in due compliance of Section 3 of the Act. A panchnama was drawn in the presence of two independent witnesses to cover the incident of detainee's refusal in accepting the ground of detention as per the extant principles of law. The panchnama bears the signature of the detainee with a remark, "I have refused to receive any document." This sufficiently indicates that twin test enshrined in Article 22(5) of the Constitution of India was duly complied with. Even in the grounds of detention, there are adequate averments clearly indicating detainee's right to make representation to the named authorities. The contention raised is only an afterthought and therefore, the present appeal deserves to be dismissed. Despite refusal of the detainee, on the first occasion in receiving the grounds of detention, a second attempt was made on 3 October 2023, and ultimately on 10 October 2023, the detainee received the ground of detention with all the relevant documents. These chronological events amply suggest the conduct of the detainee in evading to receive the grounds of detention. Article 22(5) of the Constitution of India can broadly be divided into two parts. Of these two parts, there lies an underlying duty and obligation on the part of the authorities in not only serving the grounds of detention as soon as the case may be, after due service of the detention order and communication of the grounds of detention along with the documents relied upon in the language which he understands, but also for the purpose of affording him the earliest opportunity of making a representation questioning the detention order. Para change. 9. Therefore, the first part involves the bounden duty of the authorities in serving the grounds of detention containing such grounds which weighed in the mind of the detaining authority in passing the detention order. In doing so, adequate care has to be taken in communicating the grounds of detention and serving the relevant documents in the language understandable to the detainee. The second part is with respect to his right of making the representation. For exercising such a right, a detainee has to necessarily have adequate knowledge of the very basis of detention order. There is a subtle difference between the background facts leading to detention order and the grounds of detention. While the background facts are not required in detail, the grounds of detention which determine the detention order ought to be found in the grounds supplied to the detainee. In other words, the knowledge of the detainee is to the subjective satisfaction of a detaining authority discernible from the grounds supplied to him. It is only thereafter that a detainee could be in a better position to take a decision as to whether he should challenge the detention order in the manner known to law. This includes his decision to make a representation to various authorities, including the detaining officer. Therefore, an effective knowledge qua a detainee is of utmost importance. On the second aspect, a detainee has to be informed that he has a right to make a representation. Such a communication of his right can either be oral or in writing. This right assumes importance as detainee in a given case may well be a literate, semi-literate or illiterate person. Therefore, it becomes a cardinal duty on the part of the authority that serves the grounds of detention to inform a detainee of his right to make a representation. While the aforesaid two rights and duties form two separate parts of Article 22(5) of the Constitution of India, they do overlap despite being mutually reinforcing. Though they travel on different channels, their waters merge at their destination. This is for the due compliance of Article 22(5). The entire objective is to extend knowledge to the detainee, leading to a representation on his decision to question the detention order. Such a right is an inalienable right under scheme of the Constitution of India, available to the detainee, corresponding to the duty of the serving authority. Para change. 10. Having reiterated the said principle of law, the question for consideration is, to what extent a communication can be made both orally and in writing. In a case where a detainee is not in a position to understand the language, a mere verbal explanation would not suffice. Similarly, where a detainee consciously declines to receive the grounds of detention, he has to be informed about his right to make a representation. In such a scenario, the question as to whether the grounds of detention contain a statement that a detainee has got a right to make a representation to named authorities or not, pales into insignificance. This is for the reason that a detainee, despite refusing to receive the grounds of detention, might still change his mind and receive them if duly informed of his right to challenge a detention order by way of a representation. We may clarify, in a case where a detainee receives the ground of detention in the language known to him, which contains a clear statement over his right to make a representation, there is no need for informing verbally once again. Such an exercise, however, would be required when the grounds of detention do not indicate so. On facts, we find that the detainee is not entitled to any relief, as he has not only suppressed the facts as proved in his refusal to receive the grounds of detention, apart from reading them in detail, but has also approached the court with unclean hands. It seems to us that it is a deliberate ploy adopted by the detainee to secure favorable orders from the court. A perusal of the Panchnama clearly indicates the adequacy of his knowledge in English, as he has not only signed the document in English but also made his objection with respect to receipt of the grounds of detention. We find no error in the procedure adopted by the respondents, as due compliance was made to translate all documents in Bengali apart from persuading the detainee to receive them. In addition, the Panchnama was signed by the independent witnesses. The detainee also read the grounds of detention and the relevant documents. Therefore, he was well aware of his right to make a representation. As discussed, the grounds of detention forming the basis of the satisfaction of the detaining authority were made known to the detainee. He cannot seek all the facts, including access to the telephonic conversation relied on, especially when he did not exercise his right to make the representation. It is pertinent to mention that we are only dealing with the validity of the detention order and not a regular criminal case against the accused. The other grounds raised also do not merit any acceptance, in the light of our earlier discussion. We also find that the grounds of detention were attempted to be served on the detainee at the earliest point of time, that is, on the very next day after his detention. Thank you, students. We meet tomorrow at 6 p.m.